Our next speaker is Associate Professor Dr. Michelle Evans of the Law School at Curtin University. She has a PhD with Chancellor's Commendation for Academic Excellence for her thesis titled The Use of the Principle of Subsidiarity in the Reformation of Australia's Federal System of Government, which was published in Curtin University in 2012. Dr. Evans is also the co-author of a textbook on administrative law with editions published in 2010 and 2015, and was the lead editor of the book Global Perspectives on Subsidiarity, published by Springer Press in 2014. Her research interests include federalism, administrative law in a university context, and the regulation of online content. Dr. Evans also has substantial experience in university management, most recently as the former Deputy Dean of the Curtin Law School, as well as having a current legal practice certificate from the Legal Practice Board of Western Australia. She is a member and Deputy Chairperson of the Prisoners Review Board and has recently been appointed to the Consumer Advisory Committee, a statutory committee established under the Fair Trading Act of 2010 of Western Australia. And the topic that she will be addressing us on is that of subsidiarity and federation. And I ask you to welcome Dr. Michelle Evans to the podium and thank her for her contribution this morning.
First of all, may I say what a great honour it is to have been asked to speak at such a prestigious and well-respected conference, particularly as this year marks the 25th anniversary of the establishment of the Samuel Griffith Society. And I'm also very honoured to be speaking alongside His Honour Justice Mitchell of the Court of Appeal of Western Australia. And I note that His Honour appeared as counsel for the state of Western Australia in many important constitutional cases, including work choices and HAR, which I'll mention later in my presentation today. So today I've been asked to speak about federalism and the principle of subsidiarity. And as Michael mentioned, I completed a PhD on this topic in 2012 and subsequently edited a book on that topic with my colleague Dr. Augusto Zimmermann, who will be speaking later on this afternoon. And subsidiarity has many meanings and many applications. So this book was really a collection of chapters written by Australian and international authors on the different applications of the principle, and I'll talk about some of those today. It did include a chapter that I wrote on subsidiarity and federalism, so some of my presentation draws upon this previous work. Now, speaking about concepts such as federalism and subsidiarity might at first sound quite theoretical and quite academic. But the increased centralisation of legislative and associated financial powers in particular has had a very real impact on the states. And everyone present here at the conference would be well aware of the dire financial situation in which West Australia currently finds itself, and the inadequate proportion of GST revenue that Western Australia currently receives. So this is an issue that has received much media attention, including when I was driving here this morning. So I'll turn back to that later in my presentation. So first I want to explain what subsidiarity is, what it means, and how it is a key characteristic of federalism. And I then want to just briefly touch on the federal nature of the Australian Constitution and how Australian federalism has been compromised in favour of centralisation. And I'll conclude with some specific comments about Western Australia's predicament and some suggestions for reforms, both idealistic and realistic. I am an academic after all, so I like to be a little bit idealistic and put some interesting reforms out there for discussion. So firstly, the principle of subsidiarity. What does it mean? Well, it means different things in different contexts. And it really came to prominence with Pope Pius XI, who wrote about it in an encyclical letter called Quadragesimo Anno in 1931. And the Pope was basically concerned with empowering the individual. So individual citizens would have the autonomy to look after themselves and to resolve their own issues without unnecessary interference by the government. And if the individual can't assist themselves, there's a hierarchy of assistance from the individual. So the individual would turn to their family for assistance. If their family wasn't able to assist them, they might turn to their local community for assistance. If their local community couldn't assist them, government would basically be a last resort. So basically the individual is empowered and problems are resolved closest to where they arise. And so similarly, in a political or governmental context, subsidiarity is also about empowering the individual against unnecessary government interference. So in a governmental context, subsidiarity means that decisions, so it should be legislative, it could be legislative action or administrative action, should be taken at the lowest possible level, so as close to those affected by that particular issue. So it presupposes an allocation of decision-making powers to ensure that decisions are taken at the appropriate political level, but with a focus on decentralisation, a fallback on decentralisation. So the principle of subsidiarity in a political context aims to empower individual citizens and to enhance democracy. So it encourages decision-making close to where the actual problem occurred, and it can therefore provide for more regionally appropriate and more efficient action to be taken than if it were taken at a central level. And these advantages, together with checks and balances on centralised power, through power being divided rather than being concentrated, are key advantages of subsidiarity. So although subsidiarity generally discourages decentralisation, at the same time it can provide for justification of certain matters to be resolved at a central level if they can't be appropriately resolved at the local level. The principle of subsidiarity is also embodied in the European Union treaty documents, most particularly in Article 5.3 of the Treaty on European Union. Many of the member states, including countries like Germany, were very concerned that upon joining the European Union, they would lose their national autonomy, or somehow their national autonomy over particular issues might be compromised. So that's why the principle was included in the Treaty on European Union. So returning to the concept of federalism and subsidiarity, it's correct to say that they have much in common at a theoretical level. And it's been noted that federal systems across the world basically have subsidiarity as a central principle. So they're designed in accordance with the principle of subsidiarity. And part of that is that the central government has a supporting role and only acts if the regions are incapable of acting on their own. In the 2009 final report to the Council for the Australian Federation, subsidiarity was cited as one of the fundamental rationales of federalism and a well-documented driver of effective federations. So subsidiarity enhances federation, and it's intrinsic to the efficient and effective allocation of responsibilities in a federal system. So state and territory governments are closer to the communities, and they're better able to represent those communities and to resolve issues at that level. And it's been said that the closer the proximity of government to the community, the more authentic that notion of representative government becomes. So both of these concepts have a similar underlying philosophy. So they both have similar values, such as decentralisation, regionalism, empowering the individual through greater democratic participation. And both of the concepts mandate checks and balances on power, so that power is distributed and government's more accountable, because it's not just held by one level of government only. Coming to the topic of subsidiarity and federalism in the Australian Constitution, this was certainly the philosophy adopted by the framers of the Constitution. So they intended to protect state power and autonomy against centralisation. They wouldn't have been familiar with the term subsidiarity, but it was certainly a characteristic that they sought to preserve in the federal nature of the Constitution. So they intended, upon federation, to create a system of government where the states did not lose any more powers than were absolutely necessary. And they in fact intended the states to be in a position of equality and certainly not be subordinate to the Commonwealth. There are so many instances of this intent in the Constitutional Convention debates that I chose in my paper to quote Alfred Deakin in the Sydney session of the 1891 Constitutional Convention. And he said, and I quote, "It is not a question of establishing a federal legislature which is to have unlimited authority. The federal government is to have a strictly limited power. It is not to range at will over the whole field of legislation. It is not to legislate for all conceivable circumstances of national life. On the contrary, its legislation is to be strictly limited to certain definite subjects. The states are to retain almost all their present powers and should be quite able to protect their own rights." So the Constitution, as the framers intended it, was indisputably federal. And Professor Greg Craven has said that if one had to pick the great theme of the Constitution, it could only be federalism. And this is something that we can see in the provisions of the Constitution itself. In Section 7, the framers provided for the Senate, and their view was that the Senate would specifically represent the people of each state and protect state interests when passing legislation in the Senate and guard against Commonwealth encroachment on state powers. And of course, we also know that the framers sought to preserve state constitutions, state powers, and state laws, except to the extent that they had been allocated to the Commonwealth on federation through Section 106, 107 and 108. We can also see subsidiarity in Section 51 in the allocation of the legislative powers to the federal parliament. And these include subjects that are more appropriately dealt with at a federal level, so things like defence and currency and international trade and commerce and so on. And notably, unlike state constitutions, which give the state parliaments broad legislative powers to make laws for the peace, order and good government of the state, as described by Alfred Deakin in that preceding quote, the framers limited the central government's power by listing them. So I think it's fair to say that subsidiarity is evident in the Constitution as the framers intended it. So where did federalism and subsidiarity go? I think that's something that all of the attendees at this conference will be very familiar with. So I'll just summarise this briefly. So I think it's relevant to mention the early High Court, led by the Honourable Sir Samuel Griffith as Chief Justice. And the early High Court, under his leadership, sought to preserve the federal balance of power between the Commonwealth and the states. And Sir Samuel Griffith was certainly very well placed and well informed to this task. He knew exactly what the framers intended, having been one of them himself, and indeed part of the drafting committee at the 1891 Constitutional Conventions in Sydney, which produced the first draft of the Constitution. And so under his leadership, the early High Court employed the Reserve Powers Doctrine and the doctrine of implied intergovernmental immunities to preserve this federal balance. So in the paper itself, I do talk a little bit about these doctrines, but in the interest of time today, we'll move on. Now, these federalist doctrines were decisively rejected, as we all know, by the High Court in the Engineers decision. And the composition of the High Court at that point had drastically changed from the federalist Griffith High Court, which could perhaps explain in part why they adopted a literal and consequentially centralist approach. It was a very controversial decision, as we know, because it reversed the earlier approach and the earlier line of authorities of the Griffith High Court by endorsing an expansive interpretation of Commonwealth powers without limitation by any concept such as federalism. And Professor Greg Craven has strongly criticised the Engineers High Court for this decision, saying that it irreparably altered the balance of power between the Commonwealth and the states. And the result, as His Honour mentioned, was a series of High Court decisions which Craven describes as one that must rival any win-loss ratio in the history of either professional sport or dubious umpiring, given that the Commonwealth was always successful. These decisions include the aftermath of Engineers, many decisions, but I just wanted to note a couple that I think are particularly relevant to this presentation. And they include the first and second uniform tax cases, because as we would all know, until World War II, Australians paid income tax to their state governments, who distributed the proceeds between both the state and the Commonwealth. But in 1942, under the guise of the defence power, the Commonwealth passed several pieces of legislation that centralised income tax, and that withstood two High Court challenges in the first and second uniform tax cases, thus reinforcing the centralisation of income tax and ensuring the state's reliance on grants from the Commonwealth. Other notable decisions were HAR and work choices. HAR affirmed a broad interpretation of the definition of excise duty in section 90 of the Constitution, which is exclusive to the Commonwealth, which resulted in a revenue loss to the states of $5 billion per annum. In work choices, a majority of the High Court, under a broad definition of trading corporation, effectively took the power to regulate employment away from the states, with 85% of employees being brought under the federal jurisdiction. I mentioned in my paper as well the very powerful dissents of Justice Kirby and Justices Callanan in work choices, who really emphasised that federal nature of the Constitution. We can see traces of subsidiarity. So to summarise all of that, the principle of subsidiarity has gradually been eroded and removed from the Australian federal system of government. So instead of matters being resolved at a decentralised level, increased centralisation is apparent. And instead of each level of government being autonomous, we can see central power increasing at the expense of state autonomy. Now, particularly in a financial sense, and I think because obviously talking about federalism and subsidiarity are very sort of theoretical academic things to do, I want to return to the very real financial status of the state of Western Australia. And I note that it's probably particularly appropriate that this conference should be held in Western Australia this year. As you would all be aware, I think it's fair to say that the state of Western Australia is in financial crisis. ComSec's July 2017 State of the States report reports that Western Australia is the worst performing state in the Australian Federation across all of the 8 economic indicators. Additionally, West Australia is facing spiralling public debt, and it's been reported that this debt will amount to $40.2 billion by the end of 30 June 2020. Despite this dire economic predicament, Western Australia's share of GST revenue, as allocated by the Commonwealth Grants Commission, has only been recommended to increase from 30 cents in the dollar for the 2015 to 16 financial year to 34 cents in the dollar for the 2017 to 18 financial year. And when contrasted with other states, this distribution seems manifestly unfair. So, for example, New South Wales has been recommended by the Grants Commission to receive 87 cents, Victoria 92 cents, Queensland $1.18 for the 2017-18 financial year. Recent figures provided by the WA government for the 2016 to 17 financial year indicate that WA earns revenue of approximately $25.7 billion, which includes income from state taxes, Commonwealth grants and mining royalties, but has expenses of $29.6 billion, which is a shortfall of almost $4 billion. So that raises serious concerns about what will happen to Western Australia if it continues to sustain these losses, and I think it definitely highlights the need for reform. So on to the last part of my paper, I wanted to talk about some idealistic and perhaps more realistic reforms. My view is that the situation is so dire that we probably do need constitutional amendment to restore subsidiarity and federalism to the Australian Constitution. Again, I do realise that that is somewhat of an academic statement to make, given the difficulty of amending the Constitution in section 128. But I note that it's a very good thing that the Constitution is very difficult to amend. So hence my comments about being more idealistic than realistic. The framers undoubtedly thought that the federal nature of the Constitution was so obvious that they didn't need to include anything in there, or they omitted to include any provision concerning how the Constitution should be interpreted. And as a result, various interpretive techniques have been employed, or combinations thereof. So, for example, the originalist approach, which looks at the intentions of the framers as per the Griffith High Court, engineers literalism, the living constitution approach. So given this confusion, we could perhaps consider some statement in the Constitution about how it should be interpreted, particularly in light of the federal balance of power between the Commonwealth and the states. And I make some more specific comments about in the paper as to how that could look. I think it's also time for a reconsideration of the distribution of Commonwealth state powers in accordance with the principle of subsidiarity. Such a redistribution was recommended by Toomey and Withers in their 2007 report for the Council for the Australian Federation. And they say that the allocation of legislative power in the Constitution, which was undertaken in the 1890s, needs to be reconsidered today. And they comment that the most commonly used principle for undertaking such an assessment in federal systems is subsidiarity. So they say that functions should be undertaken by the states and territories or even local governments unless it's not practicable, and matters in the national interest, such as defence, or where there are national standards required as a measure of equity, so for example social security, could be carried out at a federal level. A particular aspect, I think, of this redistribution could focus on finances, because I see this as the really huge issue, state finances in our federation at the moment. And I note that approximately 1/3 of Western Australia's revenue is derived from Commonwealth grants and the redistribution of GST revenue. So we are very, very reliant on the goodwill of the Commonwealth. I was very much in favour of the idea proposed by Prime Minister Turnbull in March last year, where he suggested that the levying of income tax should be shared with the states. And it was strongly supported by Western Australia at COAG, but resoundingly rejected by the other state premiers, presumably because they were concerned about their own state's revenue declining under such an arrangement. I have also mentioned in the paper perhaps some forms to the Senate are required. However, I'll leave that discussion perhaps for this afternoon, because I note that we do have a whole session on the Senate. In terms of other more practical and achievable solutions which wouldn't require constitutional amendment, We could require that, or we could make amendments concerning the scrutiny of bills in the federal parliament. So, for example, the explanatory memorandum, which is required when any bill is presented to Parliament. So that could be required to include a statement about how the bill impacts on the federal balance and to justify how it falls within federal rather than state residual powers. It could also be made a requirement of the second reading speech as well, which presents an opportunity for the minister to be questioned about and being made to justify the constitutional basis for the bill, and in particular debate any federal implications. A further reform that doesn't require constitutional amendment is the amendment of the Commonwealth Grants Commission formula for the redistribution of GST revenue. And this was on the radio this morning as I was driving in. The West Australian Premier was asking for it to be revised to take into account population, which I think would give the state an additional $10 billion per annum. And part of the problem, I think, as well, is that the formula isn't based on the state's current financial situation. It's based on figures from 3 years ago. Apparently, we're still having a mining boom in Western Australia. Anyone who's been made redundant in the mining industry will certainly be disputing that. And a further option, which could perhaps be combined with an amendment of the formula, is to dramatically increase the dollar amount of Commonwealth grants to the states. However, I note that in 2016 to 17, the Western Australian government received a $1 billion top-up in its grant monies, but it's really proven to be insufficient. I do propose both of these options with some caution, because both of them aren't necessarily consistent with the principle of subsidiarity. They don't give the states autonomy over their own finances, because the states will be continue to be reliant on grants and the goodwill of the Commonwealth. So hence my suggestion about, I think, more meaningful tax reform, whereby the states have more autonomy to raise their own finances. So in conclusion, given the centralisation of the Australian federal system of government, I believe that reform is urgently required to restore the Australian federal system of government to be an authentic federation. And I think that subsidiarity helps to remind us of what a federal system of government is, and in particular that it should be a decentralised system of government. And I also hope that the principle can provide some guidance and perhaps some inspiration as to how state legislative powers and state finances could perhaps be restored and protected against future attempts at centralisation. Thank you.